Okay, good and bad leaver provisions. Now, these can be in a variety of different legal documents. We commonly see them in shareholder agreements and articles of association, but they're really critically important when you are issuing shares, particularly to people who have a non-passive role in the company, who are working in the company, and you might call that arrangement sort of sweat equity. They may be paying market value for those shares in the first place, or they may be gifted the shares, or they may get them through a share option share scheme arrangement like an EMI share option scheme. But you need really good legal documentation in place, including the shareholders agreement, if they're going to have the shares that govern them holding those shares. And you really need to protect the company in the event that for whatever reason they leave, you part company, something happens, and you need to get those shares back off them. And the provisions that commonly deal with this scenario are good and bad leaver provisions, and you want them drafted as flexibly as possible in favour of the company and the board, but needs to be certain clarity to make them still attractive to the employee, depending what the negotiating position is, or the person holding the shares. But broadly, good leaver, they're going to get something for the shares. They're going to get what's typically called fair value or market value, and you need that tightly well defined within the good and bad leaver provisions of the shareholders agreement, or the document that they relate to. Bad leaver, they typically don't get anything for the shares, or maybe they get the value that if they paid something for the shares, they get that back. Regardless, you need it clearly set out how the company, whether the company buys back and cancel those shares, or whether they're transferred to another shareholder, because it could be either scenario. So that's important to cover. And also something that often gets missed is what we include is a power of attorney in favour of the board, in favour of the company. So if, for example, the situation isn't that great, and the employee leaves under bad circumstances, they may not cooperate, and ideally you really need them to sign certain documents to consent to their shares being acquired, etc. And you really need that power of attorney in favour of the board or the remaining board members to sign anything on their behalf. So that needs to be included in the shareholders agreement or the other documents, so it's crystal clear that the board, for example, can sign anything on that departing employee's behalf, such as a stock transfer form, and everything is then covered. It's clean, that you can move on, you can adhere to the other provisions, but there can be no sort of issues, as it were, that makes things any harder than they need to be at that stage. We regularly advise on the good and bad leaver provisions in a range of contexts, and if you'd like any help, we'd be delighted to see what we can do. Please get in touch through our website, give the number a call on the website, send an email to wewillhelp@jonathanlee.net, and we'll let you know how we can help, whether it's a simple fixed fee appointment or a 20-minute introductory call, if it's something that might be bigger.